Okay, well, I'm not waiting for that. The Rules Committee will come to order. Tucked away in the fine print of everything from employment contracts to privacy policies is language that bars the doors of the legal system for millions of wronged Americans. It's called forced arbitration. Instead of using the courtroom to settle disputes and claims, people are required to negotiate in a conference room instead, outside the legal system and largely on terms that favor large companies or corporations. Arbitration should be a choice. It shouldn't be forced on people through jargon buried in contracts that you'd need a law degree to understand. H.R. 1423 would give employees and consumers this choice and level the playing field for all Americans. With that, let me turn to our ranking member, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. While we'd expected the committee to be meeting on 2 bills today, I understand that we will be pushing our consideration of a continuing resolution to fund the government and keep it open to a later date. I've often said this, that this is one of our most fundamental duties, to fund the government and keep it operating for the American people. I look forward to working with the committee on this bill whenever it comes up so that we may continue to fund the government while the Appropriation Committee finishes its work for the fiscal year 2020. The only bill before us today is H.R. 1423, the misnamed FAIR Act, or Forced Arbitration and Justice Repeal Act. I say it's misnamed because there's nothing fair about this bill. It would be better to call it the Trial Lawyers Protection Act because it's a bill that's written by trial lawyers for the benefit of trial lawyers at the expense of the American people. H.R. 1423 retroactively rewrites contracts binding every business and person in the United States to eliminate agreed arbitration provisions except for collective bargaining agreements between unions and employers. In a lot of contracts that we enter in our day-to-day life, like sales contracts or employment contracts, frequently there are agreed arbitration provisions. This is a simpler, cleaner, and cheaper way of resolving disputes. But if H.R. 1423 were to become law, all of those provisions will be deemed null and void, forcing every single dispute arising under almost any contract in America into litigation. Who benefits from that? The trial lawyers do, of course. It's often said that you should never ask a barber if you need a haircut. Imagine if barbers were able to pass a bill through the House that required everyone to get haircuts. That's basically what this bill accomplishes today. Only instead of haircuts, it would be forcing people out of simple, cheap, and effective arbitration system and into the costly, complex, and frequently confusing litigation system. I think this bill is tremendously misguided, Mr. Chairman, and while I frankly can't think of any amendments that would make this situation better, I'm hoping that some of my colleagues can, and I urge the committee to make as many amendments in order as possible. With that, yield back my time, Mr. Chairman.
Thank you very much. And our 2 witnesses today are Chairman Cicilline and Mr. Armstrong. And we're delighted that you're here. Anything you brought in writing will, without objection, be entered into the record. I know that there's a Judiciary Committee hearing going on, but Ms. Lesko made it here on time. So, and you did. And Mr. Armstrong made it here on time. So, you can go first.
Chairman McGovern, Ranking Member Cole, thank you for inviting me to testify on H.R. 1423, the Forced Arbitration Injustice Repeal Act, as you determine how it should be considered on the floor. Arbitration, do you want to go? All right. I just said thanks for getting me out of there. So. Arbitration provides consumers a simpler, cleaner, cheaper, and faster path to justice than does the judicial system. That is what the evidence showed the last time the Judiciary Committee performed oversight of the arbitration system during the 111th Congress. That is what the evidence showed earlier this term when we renewed that oversight in the Subcommittee on Antitrust, Commercial, and Administrative Law. In fact, the evidence in favor of preserving access to arbitration has only increased over time. Companies are continuing to improve the fairness of arbitration agreements and have long been following improved arbitration protocols to help assure due process and given to claimants against them. Problems in consumer credit arbitration considered during the 110th and 111th Congress have been resolved by the marketplace. A string of new Supreme Court decisions has demonstrated the court's confidence in the arbitration system. Even the Consumer Financial Protection Bureau's 2015 study of arbitration highlighted problems consumers would face if they have no access to arbitration. And it bears emphasis that the rise of pre-dispute mandatory binding arbitration agreements in consumer settings did not come out of nowhere. It stems directly from the reputed abuses of class actions that have plagued the judicial system for decades. That is not to say arbitration system is perfect, but the arbitration system is generally good and should be preserved. Unfortunately, that's not what this bill would do. Rather than preserve and strengthen arbitration on a bipartisan basis, it follows a partisan path to wipe out arbitration for enormous numbers of consumers and employment disputes, as well as many civil rights and antitrust disputes. But that would not do is not end the injustice, but promote it. Because what happens when everyday consumers and employees are denied rights to arbitrate, rights that their contracts guarantee them? Far too many cases, it means they will be shut out of the justice system entirely. If their claims are enough that they are small enough that they can go to small claims courts, that may still be an option. Maybe if these claimants could qualify as plaintiffs in a class action, they could join in those actions. But essentially, any case larger than a small claims court without the potential for treble or punitive damages becomes nearly impossible to pursue. No lawyer will do that type of case on a contingency fee, and hourly legal rates make it more expensive to pursue than the outcome would even close to guarantee. But millions upon millions of claimants will have neither option because they won't be able to afford a costly courtroom lawyer who can handle their individual case. And of course, even those who qualify for class actions can often expect to get nothing in return but a postcard telling them they've won a few dollars and cents or a coupon. I have personal experience with this. I got like a $13 check from Barbary when there was a class action suit for pre-law. I didn't know I joined it, but North Dakota is a mandatory bar association, so I'm assuming I got signed up. I'm guessing the plaintiff lawyer got more than $13, but I got a $13 check. Meanwhile, class action plaintiffs and trial lawyers will reap multi-million-dollar shares in fees for the recovery and dole out to the plaintiff's class members at pennies. I want to highlight one last concerning aspect of H.R. 1423, and that's that the bill will retroactively apply to the prohibition on binding arbitration provisions. Any arbitration agreement entered into prior to the bill's enactment will now be unenforceable. Retroactivity is not favored by the law. Contracting parties form agreements based on existing law. Retroactively changing the law not only breaks the reliance and expectation of the contracting parties, but it has the potential to change the calculus of the entire contract. It may alter the calculus to such an extent that a party no longer wishes to be bound by the remaining terms. This is a massive intrusion into the freedom of contract and freedom of markets. Rather than wipe out arbitration out through this bill, we should be considering on a bipartisan basis ways that we can make arbitration better. And while we do that, we should do everything we can to reform all the abuses of the class action lawsuit system. I urge the committee not to grant a rule for this bill, so members can instead continue to seek constructive bipartisan solutions and concerns about arbitration class actions. If the committee grants a rule, I urge that a rule order the amendments co-sponsored by Ranking Member Collins and the others needed amendments filed by our colleagues on my side of the aisle. Thank you.
Mrs. Cicilline.
Thank you, Mr. Chairman and distinguished members of the Rules Committee. I appear in support of H.R. 1423, the Forced Arbitration Injustice Repeal Act, or the FAIR Act. Buried deep within the fine print of everyday contracts, forced arbitration clauses block American consumers and workers from their day in court to hold corporations accountable for breaking the law before disputes even arise. This private system does not have the same procedural safeguards of our justice system, is not subject to oversight, has no judge or jury, and is not bound by laws passed by Congress or the states. And when forced arbitration is combined with non-disclosure agreements, it effectively silences the victims of rampant corporate misconduct. This outrageous practice is nothing short of a corporate takeover of our nation's system of laws, and the American people have had enough. The overwhelming majority of voters, including 83% of Democrats and 87% of Republicans, support ending forced arbitration. It's time to act. H.R. 1423, the FAIR Act, does just that. This important legislation ends the use of forced arbitration in everyday consumer, employment, antitrust, and civil rights disputes. It's also supported by a broad coalition of public interest organizations, including the Leadership Conference on Civil Rights, the American Association of Justice, Public Citizen, Consumer Reports, and the American Antitrust Institute, to name a few. The FAIR Act currently has 222 co-sponsors and is, in fact, a bipartisan solution to the problem that has been described. I urge my colleagues to support this measure and request that the Rules Committee provide an appropriate rule to govern its consideration.
Well, thank you very much. You both were succinct and to the point and made your case, and so I have absolutely no questions. I yield to the gentleman from Florida, Mr. Hastings.
I'm more succinct than you. I don't have.
Mr. Cole.
Unfortunately, I'm not quite as succinct. But first, Mr. Chairman, I would ask unanimous consent to place a statement of administration policy into the record. That indicates that this bill, in the unlikely event it ever passed the United States Senate and reached the President's desk, the President's advisors would advise that he veto the legislation.
Without objection.
Thank you very much, Mr. Chairman. In terms of the questions, Mr. Armstrong, our friends across the aisle seem to have an underlying presumption here that arbitration is somehow unfair or, frankly, less fair than litigation as a means of adjudicating disputes. I obviously disagree with that premise, and I believe it fails to account for certain realities in the legal landscape. Is it fair to say that forced litigation bill unrealistically assumes that for every dispute, a lawyer would be willing to take the case regardless of the economics and the financial resources available?
Yeah, Mr. Chairman and Ranking Member Cole, I think yes, and also that a potential plaintiff can afford an attorney in that case. There's essentially two ways these cases are litigated. That's either on a contingency fee or on an hourly basis. And I said in my testimony, if treble damages or punitive damages aren't available and you are higher than the small claims threshold, but still, and I'll use and we've done this in North Dakota, we keep raising the rate of small claims court because litigation in court get more and more expensive. So if your outcome is going to be somewhere in that under $100,000 range without any punitive damages, there's not a lawyer that's going to take that on a contingency fee. And the cost of litigation will just essentially outweigh any benefit you have from going through it. Court fees in and of themselves are significantly higher than arbitration fees, not to mention the time and the constraints against it. So absolutely, there is a whole group of cases that exist in that space that will become very uneconomic to litigate.
You mentioned in your testimony the fact that courts can invalidate unlawful arbitration agreements. So can you explain a bit more detail how courts are already capable of doing this?
And I think that, particularly like on non-DAC, yeah, but the courts provide another layer of oversight. If an arbitration provision is unfair, courts can and do step in and declare those arbitration agreements unconscionable or unenforceable. For example, courts have invalidated limits of recovery on damages permitted under state and federal law, excessive fees for assessing the arbitral forum, requirements that arbitration take place in an inconvenient location for claimants, attempts to shorten the application of the statutes of limitations, loser pay provisions, which a claimant might have to pay the cost of arbitration or must pay the drafting party's costs regardless of who wins.
Now, to get to another potential problem here, the committee is acutely aware of the backlog in today's federal and state courts. How long does it typically take to go through arbitration versus the court system? And if H.R. 1423 were to become law, could we expect backlogs to increase?
Yeah, arbitrations are definitely, they're resolved more quickly than litigation. A recent study found that arbitration cases in which the employee plaintiff prevailed averaged 569 days compared to cases in court which required an average of 665 days. 10% of the court cases took 1,283 days, 50% longer than the longest 10% of arbitration proceedings. Another study found that awarded arbitrations took an average of just 11 months to decision versus an average of 27 months to verdict in state court jury trials.
And, this lengthier timeline, what does that mean for consumers, especially those with limited financial resources?
Well, and again, that goes to how they're paying, but if you're paying hourly for a court, the longer everything works, it goes that. But litigation is expensive and immensely time-consuming, and oftentimes, in this case, highly complicated. As the Supreme Court has explained, arbitration is usually cheaper and faster than litigation. It can have simpler procedural and evidentiary rules and normally minimizes the hostility and less disruptive ongoings of those businesses. And we've seen this in state courts. This is why you are starting to see so many more arbitration clauses in family law, which by all accounts is the highest and the most intense thing you'll ever see in a state courtroom. And rather than going away from it, in those cases that are incredibly toxic, you're seeing more and more state courts move towards arbitration.
Well, and then while the bill's entitled the Forced Arbitration and Justice Repeal Act, it doesn't really eliminate all arbitration because union contracts are left untouched. So what sort of imbalance would this strike between union and non-union employees?
Yeah, it strikes a great imbalance. Union employees would always be able to seek justice through either arbitration or the courts. Non-union employees, by contrast, would lose their arbitration rights and could, in millions of cases, go to court only if they can afford a courtroom lawyer. If they can't qualify for small claims or class action, they would be very often left high and dry.
Well, and last point, this legislation eliminates the most realistic opportunity for consumers and employers to settle disputes through the repeal of arbitration. Many of these disputes, again, involve amounts too low to attract an attorney or are not eligible to be resolved through a class action. So I asked you, who stands to benefit more from the repeal, the employees themselves or the class action attorneys who walk away with most of the settlement?
I mean, I think class action lawyers by far stand to likely benefit from this bill, more so than the employees themselves. The most significant recent evidence concerning employment arbitration is contained in a study published by INDP Analytics and funded by the U.S. Chamber of Commerce Institute for Legal Reform. In this study, the authors analyzed over 10,000 employment arbitration cases and over 90,000 employment lawsuits in federal court. This review showed that the employment arbitration compares quite favorably with litigation as a manner of resolving employment disputes and actually delivers faster, better results than does litigation. The main results of the study included that during 2014 to 18 in decided cases, employee plaintiffs prevailed in more than 32% of arbitrations, but in only 11% of litigations. Further, prevailing employees typically had won twice as much money in arbitration than litigation. The median award to employee plaintiffs was $113,000 versus arbitration was just under $52,000. And the average award to employee plaintiffs was $520,000 in arbitration compared to just under $270,000 in litigation.
And so how's replacing cost-effective and fair arbitration with with class action settlement that frequently provides, at best, a very low return to class members, while the plaintiff's attorneys take millions of dollars beneficial to themselves as opposed to consumers and employees? I mean, are we going to see a lot of that?
I think you'll see more, and I think one of the things in the time constraint we don't talk about enough is that time, like when we talk about the time from litigation, that's when it starts. I mean, just forming a class takes a significant amount of time, having enough similarly situated plaintiffs to get to that point and dealing with those in the class action. So even when you're talking about the timelines, I think it's more expedited than that because you have to get a class first. So even not only is the litigation longer, but it takes longer to get started. Well, that just doesn't, I mean, the longer you wait, the more frustration you have, and the more it costs to litigate a case is not a great way for success for either employee or a business.
Okay, well, thank you. Thank you very much, Mr. Chairman.
Thank you very much, Ms. Torres. Ms. Lesko.
Thank you, Mr. Chairman, and thank you, both of you, for being here. Mr. Cicilline, why do you think this bill carves out an exception for unions?
I think the legislation, I just want to clarify one point that was just made by my colleague. The FAIR Act doesn't take away choice. It restores choice. In fact, there's choices that have been taken away from American consumers by big corporations that don't want to face liability or public scrutiny for their actions. So the notion that somehow you're taking away the right to arbitration, what we are banning in this legislation is forced arbitration that is imposed on everyday consumers and hardworking Americans before a dispute even arises. And I think with respect to the labor exemption, there are 60.1 million workers who make up a majority of non-union private sector employees who are subject to forced arbitration clauses. Those employees are told that if they want to get a job or keep their current job, they must sign away their right to their day in court and submit to forced arbitration agreements. In most cases, they don't have a choice. In contrast, the collective bargaining process provides protections that are unavailable to many non-union workers, such as rejecting unfair employment terms. Additionally, in collective bargaining, both the company and the union are represented by counsel and can agree to arbitrate before the dispute arises on an informed basis. The collective bargaining process can also involve agreement over other important protections, such as a truly neutral arbitrator, better procedures, and transparent decision-making. This is completely different than forced arbitration of non-union employment disputes, where an employee is forced to accept an arbitration clause that is buried deep inside the fine print of a stack of confusing paperwork on a take-it-or-leave-it basis. Even when workers are aware of these clauses, it's not possible for them to know that they may be victims of sexual harassment, wage discrimination, or other illegal behavior before they can begin employment. So that's why those two categories of individuals are treated differently.
Thank you, Mr. Chair. Another question for Mr. Cicilline. Mr. Cicilline, in my notes, all three of us are on judiciary, and I know I reviewed, even though it was kind of dry, some U.S. Supreme Court cases regarding this, and they noted through the different cases that the advantages of arbitration are many, that it's usually cheaper and faster than litigation. It can have simpler procedural and evidentiary rules. It normally minimizes hostility and is less disruptive of ongoing and future business dealings. And it's often more flexible in regard to scheduling of times and places of hearings. And the court further recognized that the informality of the arbitral proceedings is itself desirable, reducing the cost and increasing the speed of dispute resolution. And these were, quite a number of years and number of cases where they repeatedly found an advantage of keeping the current system. So why do you think the Supreme Court is wrong?
I would say, first of all, it's important to remember that Justice Sandra Day O'Connor said that this represented a forced takeover of our judicial system by corporate America. So there, I think, is pretty broad consensus why forced arbitration is problematic. It's not an alternative forum for Americans. It's no forum at all. It's a rigged system that favors big corporations over everyday workers and consumers. In fact, a joint study by the Economic Policy Institute, the Center for Popular Democracy, and the National Employment Law Project described the effect of forced arbitration as an enforcement crisis brought about by unchecked corporate power. This study found an estimated 98% of workers who would otherwise bring employment claims in court abandon their effort when the only option is arbitration. And what we know for sure is forced arbitration hurts workers and consumers. Consumers and workers rarely win in forced arbitration. According to a 2017 study by the Economic Policy Institute, consumers won only 9% of the claims brought, while in stark contrast, companies won 93% of the claims they brought. Heidi Sherholtz, an economist at the Economic Policy Institute, notes that not only do companies win the overwhelming majority of claims when consumers are forced into arbitration, they win big. For example, in arbitration cases involving financial institutions, she notes that consumers rarely win. They end up paying financial institutions a whopping $7,725 in arbitration on average. The Consumer Financial Protection Bureau concluded in 2015 that, and I quote, "There is no evidence of arbitration clauses leading to lower prices for consumers. Consumers and workers rarely receive any benefit of reduced costs through forced arbitration." And in a letter urging passage of the FAIR Act, the National Association of Consumer Advocates wrote that forced arbitration results in, and I quote, "financially harmed consumers and workers left without any remedies at all," end quote. And so I think it's clear the reason the vast majority of the American people, Republicans and Democrats, support ending forced arbitration is because they know that it doesn't benefit workers and consumers. It benefits powerful big corporations, and it ought to be ended. And finally, I would say there is no prohibition against anyone agreeing voluntarily to participate in arbitration after the dispute arises if the parties agree. That is quite different than forced mandatory arbitration tucked away, hidden in small fine print that most people don't even know that they've given up their rights. And so I urge the committee to not only give us a rule, do it with enthusiasm.
And Mr. Chairman.
That may be asking too much.
Yeah, it's such an exciting topic, isn't it? Mr. Chairman, obviously we disagree. I mean, I have studies here that I can read off to that says the exact opposite, but I'll spare the whole committee of reading all that. But Mr. Armstrong, you seem to be at the edge of your seat wanting to respond. Did you want to respond?
Yeah. Well, no, I just thank you for that. When we talk about the problem with non-binding arbitration is it creates a legal fiction. And what I mean by that is one party is going to be so advantaged by not agreeing to the arbitration that there would be no case in which you do it. I'll give you a perfect example, and it's in North Dakota, where we've had an oil boom, and you're a farmer and you own 10 mineral acres and you have to take on an oil company, there is absolutely no incentive for that oil company to go to arbitration without a binding arbitration clause, because they could, I will agree with some of what was said. I think the difference is, they can chew you up in litigation. There's no treble damages. It's a contractual dispute. So there's no treble damages. There's no potential for punitive damages. There would be no way for that mineral owner to be able to afford a court case. So if you don't have binding arbitration, one side is just going to be disadvantaged so much by staying there that you're going to chase it out of the arbitration system.
And thank you. And even though I don't agree with this entire bill, I would be, just for future reference, on the sexual assault cases, I would like to look into that more. I know there's a bill out there on sexual harassment, but I don't know if it's too broad, but sexual assault, I do have a concern with that in arbitration employment clauses. Thank you.
And this bill does apply to those cases, Ms. Lesko. Just
Perlmutter.
And I appreciate the gentlelady from Arizona bringing that up, because that's the problem with the forced arbitration statute that we have in federal law today. And I've tried a lot of arbitration cases. I was an arbitration judge or a panelist several times in takings cases and in bankruptcy cases, and I tried a lot of cases in front of the courts. And what this really does is it takes away the choice from the plaintiff. And you recited a couple Supreme Court cases. I'll give you one, Wilco versus Swan, which viewed arbitration as an inferior and disadvantageous forum for the vindication of plaintiff's statutory rights. And if this were limited to a few things, maybe it'd be okay, but we're talking about employment rights, sexual harassment and sexual assault, discrimination, ERISA, fraud, customers and consumer actions, malfunction of equipment, products liability cases, and the real problem is it's an unequal bargaining position. So this isn't, I disagree with you, Mr. Kelly, this isn't just, the part of the vacuum cleaner didn't work and it's $12 and they sold 1 million vacuum cleaners and it's that kind of class action. This could be serious disagreement from, a vice president of a company who has signed an arbitration clause who's been assaulted by her boss, but held to forced arbitration. And so you come not to the court, which we have as Article 3 of our Constitution. Not arbitration was not part of our Constitution. So the value of Mr. Cicilline's bill or of this particular bill is it gives people choice again. And it may be that we want to be more selective, but to take away employment rights, to take away claims against discrimination or sexual assault or harassment, fraud, products liability, it's gone too far. And it's been only the current court that has enforced this to such a great extent. And so I would just say, having been on both sides of this, representing the businesses who've sought arbitration, been an arbitration panelist, tried cases, we've gone way too far on arbitration, and it's taken away a lot of rights of a lot of people. And with that, I yield back.
Thank you. Mr. Waddle, you just came in. You want any?
I didn't, but in case I missed something, I heard Mr. Armstrong's testimony.
Oh, good.
I wanted to clarify. I agree with my friend from Colorado that voice is important, but my understanding of reading the language was that it takes away my ability to choose to put arbitration into a contract. As a vendor of a product, selling to a larger operation like a Walmart, I am still allowed to put, I as the one who's going to be bullied by the large corporation, I can opt to put the no clause, there shall be no enforceability clause is not applicable to a vendor-to-vendor contract?
Again, if the parties agree to arbitrate, both parties agree voluntarily after the dispute arises, there's no prohibition.
I'm talking about before if I'm doing business with Walmart, I'm going to get crushed by their attorneys. I have no shot at all in the judicial system. Maybe I could get an attorney as good as Ed, but I probably couldn't afford that. My expectation is I'm going to get bulldozed in the legal system, and so I want to choose arbitration in my contract, and my understanding of this language is it prohibits that going forward. Mr. Armstrong?
Mr. Chairman, more importantly, if you negotiated that contract, say 10 years ago, it prohibits that as well. It retroactively applies.
Retroactively applies. I had an arm's length transaction, made the agreement between two parties that they would in fact enter into arbitration with me if something went wrong, and now this federal law will say no, that agreement that was made peer-to-peer is no longer valid.
Yes.
Well, I was hoping that I had misunderstood.
Would the gentleman yield for
Be
a
happy to
second?
yield.
See, I think the problem is the arm's length transaction. These are not parties of equal bargaining strength, not the franchise and the franchisor even, or the vendor to Walmart, or to the guy who's on the assembly line who, needs a job and signs the thing, and all of a sudden, he loses a finger. No, that's not the right kind of thing. But something happens. He's discriminated against, but now he's subject to forced arbitration. And so I would just take issue with the arm's length transaction.
Though, again, the best part about serving on this committee is really smart people come up and fix all of my misunderstandings. I recognize the concern about forced arbitration when folks have no understanding of what's there, though they're going to be. That's one of the 99 clauses I signed. The other 98 clauses I've also been forced to sign and have no understanding of those either. But my reading of the bill is that it is so broad, it doesn't just cover the credit card statement that I sign. It doesn't just cover the car contract that I sign. It also covers the contract that I sign with someone larger and more powerful than me, where I believe I would benefit from arbitration, and I am no longer able to force that larger entity to arbitrate with me. They now can litigate with me, for which I think I will always be the poorer. Is that a misunderstanding? Isn't this really that broad?
In that example you use, if both parties agree to it, there's no prohibition.
There's no prohibition if they agree to it in the time, but a contract that I sign up front that says 3 years from now, if we have a problem, I want to arbitrate this with Walmart. I don't want them to sue me because I can't fight them. They're too big. That I am not allowed. That arbitration provision has no force of law if it anticipates prospectively that a conflict might arise for which arbitration is required.
Yeah, I don't think that example is the problem because there's a difference in bargaining power. But I think if you agreed to do that, there's no prohibition that would prevent you from doing it, from enforcing that. Presumably, if you want arbitration, they want arbitration, then there's no...
In the time, at the moment of the conflict, but prospectively, I cannot protect myself with arbitration. I recognize trying to protect folks who don't want it.
We'll get you clarification. I think you'll be protected, but we'll confirm that so you'll have no
Thank you,
questions.
Mr.
I know you guys have to go to Judiciary Committee, is that, am I right on that?
Yes.
Are there any other questions of the?
I had a quick question for David Cicilline. I'm concerned about victims of civil rights violations pursuing justice. How does forced arbitration prevent them from getting a fair hearing?
The Leadership Conference on Civil Rights, which is the kind of most important civil rights organization in this country, has been a very strong advocate for this legislation because in instances where people have civil rights or human rights violations, it is very often in those contexts, particularly in employment contexts, that they unknowingly have waived their right to litigate those claims, and there is a forced arbitration clause as part of their employment contract.
Thank you.
Mr. Armstrong,
He has nothing to say.
I have nothing to say. Me and Mr. Cicilline are
okay.
going to walk
We have
away.
votes.
all right. You may be excused. No, anyone else wish to testify? There being none?
Mr. Chairman,
Yeah,
I did have
Mr. Morelli.
just a comment I wanted to make, although I'll wait until they...
Go ahead.
So as I was listening to this, what Mr. Woodall said relative to the small company that would somehow force Walmart to an arbitration hearing, I get that. Walmart can at any time agree to do the arbitration. We're not trying to protect the big folks from the little folks. It's the other way around. I mean, you can always enter into arbitration, unless I'm missing the point here. The question wasn't whether arbitration is of value or not. The question was whether or not someone with very limited economic ability could be forced into arbitration. I think that's the point. I was struck by your comment on it. I can't imagine some small vendor getting Walmart, pushing Walmart into the corner where they're forcing them to do arbitration. It doesn't seem to me like that's a realistic.
If the gentleman would yield,
I'd be happy to.
it's not that you're forcing Walmart, it's that Walmart today has an arbitration clause in those contracts. So my family business that vends to larger businesses, that arbitration clause is already in there. My reading of this language is that it is so broad, it prohibits me from having an arbitration, that if I, as the small guy, feel advantaged by knowing that if they come after me for failure to perform, it's going to get decided by an arbitrator instead of by a full-scale litigation, that I no longer have that privilege in America. Now, if, when Walmart gets upset with me, I ask them to arbitrate and they agree in that moment, we can certainly still go to arbitration. But I can't protect myself up front and avoid litigation as I read the language. And I recognize this is not the intent of the language. This is just what I believe the extension of the language happens to be. And I appreciate the gentleman for yielding.
Well, without belaboring it, my view of arbitration, I'm not an attorney and I don't play one on TV, but I was involved in several instances of arbitration when I chaired the insurance committee back in New York. And the idea of arbitration isn't to advantage one party over the other, it's to have both parties agree that it's a way to avoid litigation. But forcing one party over the other, particularly when you have a significant economic advantage over them, seems to me the protection that we're trying to afford people, where arbitration remains a viable option, but it doesn't. It's not forced on you by a person or a party that has a substantial economic advantage over the other. Thank you.
Thank you. Seeing no other members who wish to testify, this closes the hearing on the FAIR Act. At this time, the chair will be in receipt of a motion from the distinguished gentleman from California, Mr. Torres.
Mr. Chairman, it is with great enthusiasm that I read motion for H.R. 1423. Mr. Chairman, I move the committee grant H.R. 1423, the FAIR Act, as a structure rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purposes of amendment and amendment in the nature of a substitute, consisting of the text of Rules Committee Print 116-32, modified by the amendment printed in Part 8 of the Rules Committee Report, and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes an order only those further amendments printed in Part B of the Rules Committee Report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, and shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and the opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. The rule provides one motion to recommit with or without instructions, and the rule waives the requirement of Clause 6A of Rule 13 for the two-thirds vote to consider a report from the Committee on Rules on the same day it is presented to the House with respect to any resolution reported through the legislative day of September 20th, 2019, relating to a measure making or continuing appropriations for the fiscal year ending September 30th, 2020. Finally, the rule provides that it shall be in order at any time on the legislative day of September 19, 2019, or September 20th, 2019, for the Speaker to entertain motions that the House suspended the rules and that the speaker or her designee shall consult with the minority leader or his designee on the designation of any matter for consideration pursuant to this section.
Thank you. As you heard from the gentlewoman, this rule provides for consideration of the FAIR Act under a structured rule. The rule self-executes a manager's amendment, making technical corrections to legislation, and makes in order 2 amendments, 1 Republican and 1 Democratic, very balanced. The rule provides suspension authority through this Friday, September 20th. Finally, the rule provides same-day authority through the legislative day of Friday, September 20th, for measures making continuing appropriations for the fiscal year 2020. Giving us the ability to expeditiously take up the CR and send it over to the Senate to avert another costly and painful government shutdown. You've heard the motion from the gentlewoman from California. Are there any amendment or discussion? I'll go to Ms. Lesko.
Mr. Chair, maybe you'll have it in your heart to rule this one in order to, since Mr. Sensenbrenner has been here so long and is going to retire. Mr. Chairman, I have an amendment to the rule to make in order Amendment Number 8 to H.R. 1423, offered by Mr. Sensenbrenner of Wisconsin. This amendment preserves the enforceability of any covered pre-dispute mandatory binding arbitration agreement or pre-dispute joint action waiver unless the claimant's attorney in alternatively filed court litigation files with the court an affidavit describing the manner in which counsel will receive its attorney's fees, and with such fees being limited to a reasonable level. And so in the actual amendment, if you read it, he has several ways to determine if it's a reasonable attorney fee. So basically, it's saying you can have, you keep what's currently status quo, unless counsel shows how much they're going to get, how much they're going to charge the client, and that it has to be reasonable. And with that, I ask for approval.
Any discussion on the Lesko amendment? Hearing none, the vote is on the Lesko amendment. All those in favor say aye.
Aye.
Opposed, no. No. Can you hear the noes have it? Clerk will call the roll.
Mr. Hastings?
No.
Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? Mr. Murley? Mr. Murley, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No. Can you
Mr. Chairman,
report
no.
how Mr. Burgess was recorded?
Mr. Burgess is not recorded. Mr. Burgess, aye.
Clerk, report the total.
4 yeas, 6 nays.
Amendment is not agreed to. Further amendments. Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment to move that the committee provide an open rule for H.R. 1423. Arbitration comes or gives consumers a simpler, cheaper, and faster path to justice than the judicial system. That's not to say that the arbitration system is perfect, but it generally is good and should be preserved. Rather than wiping arbitration out and leaving Americans with no alternatives but an unreformed and unbalanced litigation system where plaintiff class action attorneys stand to benefit the most, we should be working together in a bipartisan fashion to consider new ways to make it better. I'm particularly struck, frankly, by Mr. Woodall's point. Remember, if we go back, we're undoing every contract in the country, including a lot of them that the small guy thought that was the best deal for him, was arbitration as opposed to litigation. We don't have any method to protect those people who negotiated for arbitration. We're just eliminating it and putting them at the mercy of the other party that may, as Mr. Woodall suggested, have much more in the way of litigation firepower, if you will, and much deeper pockets. I think that's a big mistake. That's us unilaterally making that decision for millions of contracts in the country. So for that reason, I think, H.R. 1423 is an ideal candidate for an open rule, and I would urge that we have one.
Appreciate it. You heard the amendment from the gentleman from Oklahoma. Any comments or discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. You chair the noes have it.
Roll call, Mr.
Recorded vote has been requested. Clerk will call the roll.
Mr. Hastings?
No.
Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? Mr. Murley? Mr. Murley, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
3 yeas, 6 nays.
Amendment is not agreed to. Are there further amendments? Seeing none, the vote is now on the motion from the gentlewoman from California. All those in favor say aye. 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 Opposed, no?
No.
Opinion of the chair, the ayes have it.
Like a roll call, Mr.
Clerk will call the roll.
Mr. Hastings? Aye. Mr. Hastings, aye. Mrs. Torres? Mrs. Torres, aye. Mr. Perlmutter? Aye. Mr. Perlmutter, aye. Mr. Raskin? Ms. Scanlon? Mr. Morelli? Aye. Mr. Morelli, aye. Ms. Shalala? Aye. Ms. Shalala, aye. Mr. Desagne? Mr. Cole?
No.
Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mrs. Lesko? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk, report the total.
6 yeas, 3 nays.
And the motion is agreed to. Accordingly, the gentlewoman from California, Ms. Torres, will manage it for the majority.
And for the Republicans, Ms. Lesko.
Ms. Lesko for the Republicans. Without objection, the committee is adjourned.
Pretty quick. That may be a record.